Hello, I'm Barina of Barina Attorney at Law, and today I would like to talk to you about something that's relatively new in Texas standing orders. Before I do though, I'd like to invite you to contact me for a consultation if you are thinking about divorce or your spouse has served you with divorce papers. That way we can sit down and talk to you and help you develop a plan that turns out best for you and best for your family. Now, Texas standing orders. Most of the time prior to the imposition of these orders, people, when they started the divorce process, they would ask for a temporary restraining order, which forced the court to have a hearing in the next 10 to 14 days. If the hearing wasn't occurred or didn't occur within the 14 days, then the TRO, or the temporary restraining order, would be dissolved. And people were asking for things in the TRO that the Texas courts quickly realized, or finally realized, that they could take care of without people having to file it. And in fact, if you wanted a temporary hearing or temporary orders, they could take care of 90% of that through a standing order. So a number of counties started developing their standing orders, but most of them have a couple of things in common. One, it's a status quo order. It says, do not do things to the other party. Don't discontinue insurance on their car. Don't change the utilities. Don't cancel the utilities. Make sure that payments are continuing to be made on those community property items. It also goes on to talk about children of the relationship. And what it says to that is, don't change where they're going to daycare. Don't change their schools. Don't change their normal living place, their abode. So maintain the status quo until a Texas court can hear the issues. Some go a little bit further. They add a geographic restriction, some of them to the state of Texas, but some of them to the county where the case is filed, where that child has been living. Now, if neither party asks for a temporary order or asks to change this Texas standing order, then it becomes the order after 10 to 14 days. Now, when a party files the divorce or a suit affecting the parent-child relationship to establish a relationship with the child, that standing order becomes binding on that party. And they will take that standing order and they will attach it to the paperwork that's given to the other party. Once that other party is served with that paperwork, then it becomes binding upon them by order of the court in all of the family law cases in that court. And again, the courts give you an opportunity to come in to ask for some changes. And what could be some of the changes? Some of the changes would be, Judge, name me as the person who has the right to establish where the child lives. Judge, name me as the party that gets to collect child support and medical support for the benefit of the child. Judge, give me exclusive use of the home. Judge, give me these certain rights with the children or other property, cars, and things of that nature. And those the courts will take up. But that doesn't happen in every case, so it gives the court the ability to somewhat say, these are the standard things, so abide by them, and it will lessen the friction. There is a be civil portion. In other words, don't be nasty, don't harass the other person, don't change their mail, don't intercept or read their mail, stay off of their electronic and social media devices. If you don't ask to change it, that becomes, like I said, the order of the court, and that will last until a temporary hearing or until the final order of the court. One thing that's really interesting about some of these Texas standing orders is they have provisions that if you're to ask for a temporary hearing, what happens? They'll set time limits on the prospective temporary hearings. In some of the counties I practice in, you can go from 40 minutes up to 2 hours. When I say the 2 hours, what I'm really saying is an hour for each party. When I say the 40 minutes, I'm talking about 20 minutes for each party. So we're talking about the total. That's going to be in the court standing orders. Also, the items you have to bring to court at a temporary hearing or a final hearing are in those temporary orders. A property division form for final. For a temporary hearing, they're going to want financial information. How much you make. What are your bills? That way, if you're obligated or ordered to pay child support, the judge is able to calculate it. For a final hearing, they're going to want that same information. So please read over anything you're served with. Go over what you're served with an attorney. But pay particular attention to the standing orders. They'll give you a lot of the explanations, but they'll also impose obligations and responsibilities on you. If you do not live up to these obligations and responsibilities, you may be called to answer for it later, and that's something you don't want to do. You want to follow these orders perfectly based on your understanding with an attorney. Again, if you have the need to file a divorce or you're responding to a divorce, contact me, Bobby Dale Barina, attorney at law, and allow me to spend some time with you and talk about these solutions. These solutions that will ensure you access to your children and reach the best possible outcome for you. Thank you.